Hello everyone. In the previous video, we discussed about relevant facts and admissible facts and what is relevant facts all about. In this video, we will discuss about the important topic that is Section 6 of Indian Evidence Act, Res Gestae. Section 6 of the Indian Evidence Act deals with facts forming part of the same transaction. It says that even if a fact is not itself the main fact in issue, it can still be proved if it forms part of the same transaction. Now, what does this mean in simple terms? It means that a crime or event does not happen alone. It happens with surrounding actions, words, reactions, and circumstances. Law understand that these surroundings facts are sometimes necessary to understand the full story. The principle behind this section is called res gestae, which means things done. The idea is that when different acts are so closely connected that they form one continuous story, the court should not separate them artificially. If we separate them, we may lose the real meaning of what had happened. If we consider an example, if during an attack the victim shouts like he is stabbing me, that statement becomes relevant. Why? Because it was made at the same moment of the attack. It is not a planned statement, it is a natural reaction of the victim. That is why law trusts it. Now let us see what the same transaction really means. The term same transaction is not clearly defined in the Act, so courts interpret it based on circumstances that had happened. A transaction means a series of acts so connected that they form one complete event. Court usually examines three main factors. The first one is proximity of time. Did it means did it happen at the same time? Proximity of place. Did it happen at the same location? Continuity of action. Was there a continuous chain of events? If there is a long gap or clear break in these events, then it may not be treated as the same transaction. For example, if a robbery happens at 10 p.m. and the victim immediately screaming identifying the robber, that is same transaction. But if the victim calmly narrates the incident after 5 hours at home, that is not same transaction. That becomes a past narrative. Now let us look at the essential conditions for applying the section 6 in the Evidence Act. For section 6 to apply, certain conditions must be satisfied. The first one is the fact must be directly connected with the main event. It cannot be loosely related. The second one is the statement or act must be spontaneous. It should not arise naturally. It should arise naturally during the incident, not after thinking or planning. Third one, there must be no time for fabrication. If a person had enough time to think and create a story, section 6 will not apply. Courts trust spontaneous statements because human reactions in moments of shock or danger are usually natural and truthful. Example, if during a stabbing the victim immediately shouts the attacker's name, that is admissible. But if the victim later gives a detailed written complaint after discussion with others, that is not covered under the section 6. So the main thing what we need to remember is res gestae means things done at that particular time. Now let us look at why section 6 is very important. Section 6 is extremely important in criminal trials. Many times there may not be strong direct evidences, but immediate reactions of victims or witnesses give valuable insights into the truth. Immediate words spoken during an incident show natural emotions fear, shock, pain. These are the emotions to be considered as. Without section 6, courts would have to ignore many natural and truthful statements made during the crimes. That would weaken the justice. For example, if a sudden fight, if a witness shouts like Ravi stabbed him, at that moment of stabbing, that statement becomes relevant and powerful evidence. Now let us look at section 6 as an exception to hearsay rule. Normally, hearsay evidence is not admissible because it is kind of hear and say. Means it is like I heard from someone, I said. So usually courts do not trust hearsay because it it's second hand information. But section 6 is an exception to the hearsay rule. Why? Because statements made during the transaction are considered trustworthy. They are made in excitement or shock without time to plan a lie. So even though technically it may look like hearsay, section 6 allows it because it forms part of the same transaction. For example, if a dying victim says immediately, like Rahul attacked me, that statement can be admissible under section 6 because it was made during the event. The final understanding of Res Gestae is that to apply the section 6, always ask one question. Is the fact so closely connected with the main event that it forms one continuous story? If yes, it is relevant. If there is a break in time or connection, the section 6 Res Gestae will not apply. We must remember a few things here, that is same transaction, proximity of time and place, spontaneous statement, no time for fabrications. For example, words spoken during the crime, admissible detailed explanation give much later, not admissible under the section 6. In the next video, we will study motive preparation and conduct under section 8 and understand how intention and behavior become relevant in a case. If you found this video helpful, please share, like and subscribe. Thank you for watching and all the best for your exams.